A very good evening and a special welcome to this edition of Direct. My name is Garfield Burford. Direct this evening to the controversy over the United States request for the extradition of Tivoli Gardens strongman Christopher Dudus Coke. Direct has journeyed here to Miami in the Sunshine State of Florida, and we're here to speak with Jamaicans who are legal experts and other members of the Jamaican diaspora on this controversial issue and other matters of critical concern to members of the diaspora. Well, the United States State Department has made no qualms about its displeasure with the Golding administration's handling of the extradition request for Christopher Dudus Coke. It included that issue in a stinging report called the Narcotics Control Strategy Report for 2010. The Golding administration has shot back, saying the United States violated Jamaican wiretapping legislation when it obtained the evidence against Christopher Dudus Coke. We've come here to the University of Miami School of Law to speak first with Professor of Law here, Jamaican-born David Rowe. He shares his views on whether the Prime Minister was right in defending the constitutional rights of Christopher Dudus Coke, or whether this was a big mistake which is sparking possibly a full-scale diplomatic row between Kingston and Washington.
Talk to us first. What, in your view, where in your view did the government go wrong in this extradition request for Christopher Dudus Coke?
Well, the government went wrong by violating the traditional protocol that is associated with extradition treaties. That is, by not responding immediately to the extradition request by having an arrest warrant signed by the Director of Public Prosecutions and executed. Under the extradition treaty between the United States and Jamaica, once the actual grand jury indictment and warrant are in proper form, the other party to the treaty must react by arresting the individual for whom the arrest warrant has been issued. By not proceeding, at least since August, now with an 8-month hiatus, the government of Jamaica is substantially violating the treaty, violating the traditional extradition protocol, and violating international law.
You don't agree with Prime Minister Bruce Golding speaking in Parliament on Tuesday, March 2, 2010. He told legislators that the United States violated a fundamental principle of Jamaican law when they went about obtaining the evidence against Christopher Dudus Coke illegally by violating the interception of communications or wiretapping law. You don't agree?
No, I don't agree. The fact of the matter is that there is an enormous amount of evidence that is reflected in the indictment by the grand jury. The evidence relates to cocaine, it relates to weapons, guns specifically, it relates to a warehouse in Tivoli from which weapons and cocaine are being transported, and the mere fact that there may have been a wiretap communication that occurred in Jamaica does not detract from the huge amount of evidence that the indictment discloses. Furthermore, the indictment was an indictment in New York, and it is an indictment based on evidence presented before a grand jury by informants who testified before the grand jury about the information that they had. The indictment has nothing to do with Jamaican law. The only reason that Jamaican law is relevant in any form is because the individual is not actually in the United States. So the principle of extraterritoriality requires that in order for the United States to obtain the individual legally, they have to obtain the individual under the extradition treaty between Jamaica and the United States. So when the informants, the witnesses, the police officers, the DA agents, the ATF officers and the FBI agents testified before the grand jury, they were not testifying in Jamaica, they were testifying in the United States. And the only law that they had to comply with when they testified before the grand jury was the United States law.
But isn't it true that under the Interception of Communications Act, the extradition treaty ought to be carried out in accordance with the law of the requested state, i.e. Jamaica in this case? In other words, America wouldn't be expected, so says the Prime Minister, to break Jamaican law in securing the evidence or in obtaining the evidence against someone whose extradition they're requesting.
Well, I think it's very important when you're posing the questions and you're referring to statutes to refer to which country the statute comes from. Because when you're referring to interception, this interception statute, yes, I think that you have to make sure, make it quite clear that you're referring to Jamaican statute.
Because that is what the Prime Minister said was broken in this case, was violated in this case.
No, I understand. I understand. I just want to make it clear for the listeners. Well, there are United States cases that are on point. The main case is Lorenzo Marquez. And there's another case called Alvarez-Machin. I think the significant case is Alvarez-Machin, which clearly indicates that the United States can obtain evidence which is contrary to the law of the requested state and present that evidence in the extradition proceeding in the foreign country. In the Alvarez-Machin case, the Mexican individual was actually kidnapped from Mexico and brought to the United States. Obviously, kidnapping is contrary to Mexican law, and the United States Supreme...
By the United States?
Yes, by agents of the United States. And
as was Norris Barnes in Jamaica?
I have no information about the Norris Barnes situation. I know that other Jamaican... I know that individuals have been kidnapped from Jamaica by the United States. But I know that the current level of cooperation suggests that American kidnapping is unlikely. But getting back to your question, which is on the Alvarez-Machin case, it is feasible, possible, and jurisprudentially proper for that type of evidence to be permitted and to be used as probative evidence in the federal district court in a case against an extradited individual. And the United States Supreme Court has pronounced on the matter in the last 15 years.
Do you think it's perfectly fine for the U.S. to have obtained this evidence? So says the Prime Minister. We have no evidence that he hasn't presented any evidence of what he's saying. But on his word to Parliament, you're saying that it's perfectly fine for the U.S. to have violated Jamaican Interception and Communications law to obtain this evidence against Dudus Coke?
No. First of all, I think you're trying to put words in my mouth, which you ought not to. I'm saying that under American law, and under the Alvarez-Machin case, if there is a violation of foreign law in obtaining the evidence or the suspect, that evidence is perfectly admissible under the federal rules of evidence in the United States District Court. Now, the United States and Jamaica have arrangements concerning the conduct of informants in Jamaica. Jamaica has signed bilateral arrangements with the United States in which individuals are recruited from the Jamaican public to inform against Jamaicans in Jamaica. This is something that Jamaica did. Okay, and Jamaica, these Jamaicans, when we have cases here in federal district court, frequently I'm defending, we have Jamaicans who are paid by the Jamaican police jointly with the American police who are giving evidence against Jamaicans. And Jamaica has agreed to this. Now, having regard to those facts, it is very difficult for the Prime Minister to say that one of these informants might have used an electronic method of surveillance and violated the treaty. Now, I do not know that the Dudus indictment in any way